Alright, U.S. versus Gunnisonantirtrust oil and gas joint bidding and other collaborations. The commentary. We're going to actually look at the court case. Alright, in the United States District Court for the District of Colorado, Civil Action Number 12, CV00395, RPM, MEH, United States of America Plaintiff versus SG Industries I1 Limited, SG Industries 7 Limited, Gunson Energy Corporation defendant, stipulation by the United States and Gunson Energy Corporation. It is hereby stipulated between undersigned parties that the court jurisdiction subject matter of the action defended by the Gunson Energy Corporation or GEC waives service of summons of the complaint venue is proper in District Colorado. The United States filed a complaint in February 15, 2012, compliance alleged violation Section 1 of the Sherman Act, Title 15 U.S. 15 U.S. Standard Code 1. Parties consent with the court's entry of the proposed final judgment with respect of the Gunson Energy Corporation. Gunson Energy Corporation proposed a final judgment form attached hereto with exhibited upon motion of the United States Gunson Energy Corporation or upon the court's own motion without further notice any party other proceeding, providing that plaintiff has not withdrawn its consent, which it may do at any time before entry of the proposed final judgment by serving notice. Therefore, the Gunson Energy Corporation by filing notice of the court. Gunson Energy Corporation represents the payment ordered by the Gunson Energy. Proposed final judgment will be made. Actions required pursuant to the Gunson Energy Corporation proposed final judgment can and will be performed. That Gunson Energy Corporation will later raise no claim, mistake, hardship, difficulty, compliance, or grounds for asking court to modify any other provision contained herein. The entry of the proposed final judgment in court stipulation tells that all antitrust United States GEC arising from specific Gunson Energy Corporation arising from specific events were given the rise. The allegation described in the complaint. The stipulation does not settle antitrust claims of the United States against Gunnery Energy Corporation arising the acquisition operation of the Ragged Mountain Pipeline. In the event United States withdraws its consent provided in paragraph 3 and 3 above, or B, Gunson Energy Corporation proposed final judgment is not in pursuant to the stipulation is not expired for all of the appeals in court or ruling declining entry. Proposed final judgment, the court has not otherwise ordered to continue complying with the terms of provision proposed in the final judgment. Then the parties are released from all other obligations under stipulation. Making stipulation shall be with the prejudice any of the other proceedings, except for the defendant's waiver of the service of the summons of the complaint remains effective. Dated first day of March 2013, respectively submitted. For plaintiff in the United States of America, defendant Gunson Energy Corporation. So this is the person we got to talk to. Sarah L. Wagner, U.S. Department of Justice, Antitrust Division, Transportation, Energy. Agricultural 405 Northwest Street 800 Washington D.C. Telephone number 202-305-8915. Fax 202-616-244. Sarah Wagner, U.S. Department of Justice. Alright, for the United States District Court of the District of Columbia, Civil Action Number 12, CV00359, RPM, MEH, United States Plaintiff. SG Interest 1 Limited, SG Interest 7 Limited, Gunson Energy Corporation defendants. Alright, final judgment with respect to the defendant Gunson Energy Corporation. Whereas the plaintiff of the United States filed this complaint alleging the defendant Gunson Energy Corporation and the SG Interest 1 Limited, SG Interest 7 Limited, inclusively SGI, violated Section 1 of the Sherman Act and Title 15 U.S. Standard Code. Plaintiff, the GEC, with their respectful attorneys, consent with the entry of the final judgment without trial. For final education, issue factor, law, settlement, person without final judge, consisting of evidence against the pursuant admission of the Gunson Energy Corporation with respect to the allegation contained in the complaint. Now, therefore, before taking any testimony without trial or final injunction in the issue, factor, law therein, upon consent of the parties thereto, hereby ordered, judged, and decreed. Alright, jurisdiction. The court has jurisdiction subject matter. Each of the parties consent to hereto the complaint stated the claim against General Gunson Energy Corporation under Section 1 Sherman 2. Applicability final judgment applied with the GE Gunson Energy Commercialization successor and payment. Within 30 days of the entry, final judgment, Gunson Energy Corporation shall pay the United States amount of $275,000 to settle the claim the United States asserted against Gunson Energy Corporation on Sherman Act. Payment specified above is made with wire transfer. Making the transfer, Gunson Energy Corporation shall contain Jane Ignall's antitrust anti-document group. Section 202.514.281. In the event of default, payment interest rate of 18% per annum shall accrue, therefore, the date of the default of the antitrust compliance. Gunson Energy Corporation President shall be responsible to ensuring that Gunson Energy compliant with the final judgment. Gunson Energy Corporation President shall be responsible for furnishing the Department of Justice note that the Gunson Energy Corporation intends to bid in another party on the behalf of the whole and part. Another party leases intended to bid with another party on behalf in the whole or in part any other party or leases oil and gas lease auction conducted by Bureau of Land Management no later than 30 days prior to such action. Upon receiving a request, Department of Justice provided the Department of Justice non-privileged information, including documents relating to planned joint bidding identified with the General Gunson Energy Corporation notice. No information, documents obtained, means, sections should divulge or understate any of the person other than authorized representative of the executive branch of the United States, except the course of legal proceedings with the United States as a party, including grand jury proceedings, or the purpose of securing compliance with the final judge as otherwise required by law. Retention of jurisdiction. The court retains jurisdiction to enable any of the parties' final judgment to apply to the court anytime further orders, directions necessary to appropriate with the carry out, construe, final judgment, modify, terminate any other provision to enforce compliance and punish violations of this provision. 6. Expiration of final judgment. Unless the court grants extension of final judgment, all obligations contained herein shall be acceptable, shall expire 5 years after the date of entry. 7. Public interest. The determination, entry of the final judgment, public interest based on the record of the court will include compacted with the impact of the February 5th, 2012. Public comments. The August 3rd, 2012. The United States response. Public comments filed August 3rd, 2012. All United States motion memorandum submitted by the United States support. Final end judgment, entry, final judgment, and public interest date, and United States District Judge. Certificate of service. I hereby certify with the March 2013 Exhibit A or foregoing clerk using CEM ECF systems will send notifications such filing the email address Timothy R. Buer, Timothy.Bear, Bryant Cave, and Elpo Legitimate, Legit. And that was by Sarah Wagner, U.S. Department of Justice Antitrust Engineering, Energy Agricultural Section 450 Street, Washington, D.C., and plaintiff of the United States. That would be a really good person to contact. And that was the United States courts of the U.S. Gunson anti-risk on oil, gas, joint bidding, and other collaborations.